Welcome back to The Heat. On September 11th, 2001, Al-Qaeda hijackers boarded 4 airline jets that they used to attack several U.S. cities, killing more than 3,000 people. On that day, the U.S. government's list of people barred from flying had just 16 names. Today, that number is said to be in the tens of thousands. The actual number is classified, but we do know some of the names because of the lawsuits filed against the United States. Dr. Regina Abraham was studying at Stanford University when she tried to fly home to Malaysia for a conference. She was detained at an airport by authorities who believed she was a terrorist. She sued the U.S. Department of Homeland Security, and 9 years later, in a landmark ruling, the federal judge ruled in her favor to remove her name from the database. But for many others, their legal battle is just beginning. Well, joining us now from New York is Susan Hu. She's a fellow with the Center for Constitutional Rights. Susan, thanks for joining us. At this stage, do we know, I mean, as I said, there are tens of thousands of people on the list. Do we know how many people are challenging this in court?
Well, you know, there are a few lawsuits that are happening all around the country challenging the no-fly list. I would put the number at a dozen or a little bit more than a dozen people. But, you know, that obviously is a very minuscule number compared to the number of people who are actually put on the no-fly list or are affected and put on the, you know, broader terrorist watch list, which as of, you know, a couple weeks ago, according to a government filing in another case, that number is about 1.5 million people.
Now, you represent several men who are challenging the listing on the no-fly list. Take us through that case.
Sure. So we actually filed this lawsuit in October of 2013 on behalf of one individual. We recently amended the complaint this year to add 3 more plaintiffs to the lawsuit. We have 4 clients in the case. All 4 of them are Muslim men, and all 4 of them were approached by FBI agents at around the same time that they were put on the no-fly list or found that they were unable to board a plane. And the FBI agents repeatedly approached each of our clients and said to them, look, if you cooperate with us, we know you're on the no-fly list. We know you're not a terrorist. In some cases, that they said that to our clients. And if you cooperate with us and if you work to inform against your own community, against your own religious community, and, you know, tell us about what's going on in your community, we'll take you off the no-fly list. Our clients refused to do so for religious reasons, for personal reasons. They didn't want to get in trouble. They didn't want to be associated with the FBI, and they found themselves either on the no-fly list or they were still unable to fly. And so our lawsuit challenges that practice. And we also, of course, like many other lawsuits around the country, challenge the constitutionality of the no-fly list itself.
Well, there's been a judge in the state of Oregon who's ruled that, you know, the fact that the government doesn't tell you why you're on the no-fly list is unconstitutional. The fact that you can't challenge that is unconstitutional. Mm-hmm. How does that affect your case?
Yeah. And in that case that you're referring to in Oregon, it's the Latif case. In that case, the plaintiffs there challenged the constitutionality of the no-fly list, just like in our case. We argue essentially that it is completely unfair for the government to put someone on the no-fly list, to not tell that person why they're on the no-fly list, or even the fact that they're on the no-fly list. In fact, that information is withheld from the individual. And the process that an individual has to go through in order to try to remove their name from the no-fly list is really skimpy. Essentially, they just submit some sort of online form to DHS, and they hope that someone in the government will notice that a mistake has been made and that the mistake will be corrected. Essentially, they're not able to give any sort of additional information why they shouldn't be on the list. They're not able to see any of the evidence against them, and they're not able to challenge it in court. And so that is what the Oregon case said was unconstitutional, and we certainly hope that the judge in our case will say the same, because under any sort of you know, constitutional due process, it doesn't fly.
Right, and the standard response from Barack Obama and his Attorney General Eric Holder is that we cannot tell you why you're on the no-fly list because it would compromise national security. How do you challenge that?
Yes. I mean, that is an extremely hard thing to challenge, but it's you know, in a way, it's very sort of contradictory, right? The government won't tell you that you're on the no-fly list, but at the same time, they don't allow you to fly. And in many instances, the airline personnel at the airport actually tell the individual, "Oh, you're on the no-fly list. We can't let you on the plane." And so, it seems. It doesn't seem like the best policy to not actually tell someone that they're on the no-fly list, while at the same time essentially letting them know that that's really the only possible consequence.
Right, you know, I mentioned the case of Regina Abraham, that's the Malaysian woman who successfully challenged the government and got her name taken off the no-fly list, but it took 9 years. Why did it take so long? Was this just government stonewalling?
Yeah, I mean, I think this is the exact reason why there are so many problems with the lack of transparency surrounding the no-fly list and the lack of robust procedures to be able to challenge it. Essentially, what happened in that case, from what I understand from public documents, she was put on the no-fly list by mistake because a government agent accidentally checked the wrong box. They corrected that mistake almost immediately, but she was not notified of that mistake, and was unable to, and still was unable to fly for whatever reason. And so, even though the government had corrected that mistake years earlier, they refused to let her know, despite the filing of a lawsuit, that she was actually taken off the list. So for 6-7 years, she was challenging the case, not knowing whether or not her name had been taken off the list. And finally, you know, only after a court ordered the government to do so, it revealed that that it had made a mistake and she no longer belonged on the list. And this is really the essential problem with the secrecy around the procedures, right? She was, you know, because there were really no robust procedures to understand why you're on the list and to be able to challenge it. It took millions of dollars and a federal lawsuit in order to find out that it was a mistake that the government had made.
Okay, Susan Hu, thanks for joining us.
Thank you very much.